and then you can designate successor beneficiaries, which would be your heirs, meaning that at the time you die, your successor beneficiaries of the trust would be your children or whoever it is that you want to inherit the property. So it's kind of like setting up who owns it now, or who gets to benefit from it now, and who gets to benefit from it in your death without it having to go through probate. So it's kind of like setting up who gets to have it now and who gets to have it later without it having to go to probate. And that's what people are trying to do. It's a bit complicated, and that I've just made it as simplistic as I can, but there are some drawbacks to it. And most of those drawbacks have to do with tax ramifications. And so again, unless you have a really, really complex and an extensive portfolio with a lot of assets and different properties and business and that, I don't know that this is the best option. I would highly suggest that you speak with a tax professional, maybe a tax attorney, before really investigating that type of an instrument. And I don't feel really, really qualified to go into the tax ramifications of that one. So I hope nobody asked me that question, because that's really not my specialty. But I wanted to make sure you're aware that that is one option, and it does avoid the probate process as well. Okay, so revocable means that if you set up this living trust and it's revocable, that means that you can decide to cancel it, or revoke it. Irrevocable means that if you set up this living trust, that you cannot cancel it or revoke it unless the beneficiaries of that trust consent to it. That's the difference. And so that's the basic difference there. Okay. So, but for most people, if what they're trying to do is to avoid the probate process, for most people, the biggest asset that we have is our home. And so for most people, they can accomplish the objective of avoiding probate as it relates to their house by the next instrument called a transfer on death deed, or TODD. This is a special deed that transfers your interest in your house to a beneficiary or beneficiaries that you designate upon your death. How does this work? What happens is that you can draw up this deed and you can designate who you would like to transfer your house to. And this is only land. It doesn't relate to personal property or anything like that, only to your land or house. And so you designate who you would like your house to be transferred to upon your death. Once you draw up this deed, you have to actually file this deed in the county where that land is located. Upon your death, and then the person who is designated on this deed would have to notify the county of your death. And once that county clerk is notified, then the deed would be transferred to that designated beneficiary. Okay. You can file such a designation of transfer of deed of death. You can do this even if you owe money on the property. But you can only transfer the interest in that property that you own. In other words, let's say if you own this property together with a spouse, you can only transfer your interest, which in most cases would be 50%. Okay. If you owe money on the property, of course, any outstanding debt would have to be satisfied before you can transfer your ownership into that property. So, that type of thing. But yes, you can actually do that, and that would be effective. Even if you later fill out a will and your will says something different than what your transfer on death deed says, the deed would supersede what you say in your will. So just understand that if you file a transfer on death deed, your transfer on death deed will rule over any will that you later would draft. So those are some other parts of an estate plan that you might consider. I know that's a mouthful, but if you have questions, we'll take those questions later. Okay. So what if things change? And because they do, life happens, right? So I like to draft wills in such a way to provide for contingencies. Case in point, I like to draft wills in such a way that it says, I leave this and such an item to this and such a person. However, if this person does not survive me, then I leave it to this and such person. Okay, so I try to draft wills in such a way that they have a little shelf life to them. So, we don't have to go changing them every other year, so that's what I like to do. I draft some contingencies in them so that they, have a little shelf life. Or in terms of an executor, I name this person as executor of my will. However, in the event that this person is unable or unwilling to serve as executor at the time of my death, then this person would be my executor. I like to draft wills in such a way that I don't, let's say for personal property, I'm not going to put in a will, I give this car to this person. And, you know what I'm saying? Because by the time I pass on, I hope I will have bought a few more cars. And so what I'll say is I have, as it relates to personal property, there's a section on personal property, I will say, I have a list of my personal property attached. And so that way I can just change the list of personal property, which is attached to the will. So I don't have to change the will every time I buy a new car. So things of this nature, as it relates to bank accounts, things of that nature. I don't list every single bank account. I will just do a general thing and say, I leave my cash accounts, whatever may be in my cash accounts, to this person. And so what I think is a good idea is to do it in general terms of that nature. And so then that way, if I want to designate beneficiaries on those cash accounts, then I can do that. And so what the will kind of is like a safety net for whatever may remain that has not been specifically designated by beneficiary cards on those accounts. So if I want to be specific about those accounts, I can do that on those accounts, payable upon death benefits on those accounts. And then whatever is left that may kind of fall through, then the will is kind of a safety net for whatever remains. So I think that's a really good strategy to employ. And lastly, as I say, we do want to review them periodically. If some key family members or people are passing on, then yes, I think it's a good idea to review your estate planning documents, perhaps specifically if a spouse dies, of course, you want to review that and make sure that it still makes sense the way that it is drafted. Certainly in the unfortunate event that a child passes on, something like that, you certainly want to review your documents and make sure that they are still, that they still make sense the way that you've got them. And yes, keep them in a safe place, but again, not in a safe deposit box. You've got to be able to access them. Your executor needs to be able to get to them because the original does need to be filed with the probate court. My observations as a legal professional, that people who die without a will, I have just seen it tear families apart. I really have. I have seen families, come almost literally to blows as a result of this. And in this day and age, we have got, situations where we have blended families. We have a lot of blended families that, they seem to get along pretty well while everyone is alive. But when I tell you, when stepmom and stepmama and stepsisters and stepbrothers, the real deal shows up when people start dying, and it really can create a lot of unnecessary conflict. So when we just go ahead and make our wishes known, it just really, really, it really avoids a lot of unnecessary conflict. And I'm sure Attorney Pratt will be able to expound a lot more on what can happen when we don't have wills, because the law takes over when we don't take control of our of our lives in this way, then Attorney Pratt will be able to tell you exactly what will happen in court when we don't do that. So with that, I'll give her an extra 3 minutes. I thank you for your time, and I will turn it over to Attorney Pratt. Thank you.
Thank you, Attorney Cooper. Good afternoon. I am Attorney Tiffany Pratt, and I practice wills, estate planning, and probate law in the DFW Metroplex area. I've been practicing for a little over 13 years. And the area of probate, wills, and estate, that's one of my favorite areas to practice. I really have a passion for it. And I am happy to be here today to be presenting to you in this area, because as Attorney Cooper said, it is a very serious matter. And especially since the onset of the pandemic, I know at least in my practice and probably in Attorney Cooper's practice, I have seen an increase. I have had an increase of probate clients, and especially clients that have loved ones who passed away who did not have a will. That's pretty much probably been 85% of the scenarios that I've had dealing with probate that have come into my office. They did not have wills. And mostly everyone that comes in, they always say, well, we didn't expect a pandemic. We didn't expect this to happen. You know, we didn't think that, you know, Johnny or Sally would pass away so soon. So we didn't even think about, you know, preparing documents. And I know that's common for quite a few people. So I'm glad that you guys are here today, and hopefully that you will take into consideration what Attorney Cooper and I say today, and, you know, get you some documents, get your paperwork in order. So with that being said, if you don't have a will, it's not a big deal. Things can still move forward, but you don't have control over how your estate is going to be distributed. So when you pass away without a will in Texas, we call that passing away intestate, meaning you did not have a will in place. And when you pass away intestate, the Texas Estates Code, or the Texas law, provides how your estate will be distributed and who it will be distributed to. In this situation, it may be that your estate is going to be left to, you know, children or siblings or a parent that you did not necessarily want your estate to pass to. And we don't have any control over that. It's basically what the Texas law states. And so all the information that we have presented to you today and will present to you today is specific to Texas law. Only for the state of Texas. So this does not apply for any other state, just the state of Texas. So basically, there are 3 basic scenarios for intestate succession. And we're going to go over those 3 basic scenarios, but know that it can get complex when you start passing away. You don't have, you know, a spouse or children. Your parents have passed away, siblings have passed away. It can get complex, but today we're just going to focus on the 3 basic scenarios. Next slide, Attorney Cooper. Okay, so the first basic scenario is if you pass away without having a spouse, so if you are unmarried. Okay, so if you are unmarried, most of the time, if you have children, your estate is going to pass to your children. So your children would be considered your heirs. So let's just say you have 5 children. They each would then get an equal distribution of your estate. So if it's 5 children, they each would get 20% of your estate, or 1/5 of your estate. If one of your children have passed away and that child has children, then their children will take in their place to get their share of the estate. So it just kind of goes like that. So children, and then if one of your children or several of your children have passed away, then their children will take in their place. Typically, this is fairly easy for a female deceased person because most of the time it's easy to determine who your children are, because as women, we give birth to the children. I've seen it get pretty complicated when it's a deceased male who passes away, and especially if there were not any court orders for those children establishing paternity. So I've had lots of situations where, you'll have children, there was a court order determining that that person was the parent. But then you also have other children who come and say, hey, this was my father. And it kind of becomes complicated at that point because without a court order and without any DNA testing, it's kind of hard to determine whether or not that actually was a child of that person. So that's one issue that can arise when dealing with passing away intestate. Also, children can be considered biological children and legally adopted children. So if you legally adopted a child, that child is considered a child for all legal purposes. Sometimes I've seen a couple of cases where there was not a legal adoption, but that person took that child into their home and raised them as their own, or maybe had a custody order for them. I've had a couple of situations where the court has made provisions for that person and considered them a child. So in some very small situations, that could be an issue where a child that you took in and raised them as your own, or you had legal custody of them, may be considered an heir for that purpose. Now, if you pass away and you don't have any children, then your estate will then pass to your parents. Okay, so half of your estate will go to your mother, half of your estate will go to your father. Now, let's just say, for instance, one of your parents have passed away. If that is the case, then half of your estate will go to that living parent, and then the other half of the estate will go to your siblings. Okay. Now, if it's a situation where neither of your parents have survived, both of them have passed away before you, then your estate will then pass to your siblings equally. So it also provides further down for that, but we're not going to go into today because we can be here all day trying to determine who would, inherit your estate next if you don't have any siblings, or if you don't have any cousins or anything like that. So it can become complex, but this is just a basic scenario. Usually most people's scenarios fit into this category. They either have children or parents or siblings that are still living when they pass away. Next slide, Attorney Cooper. Okay, now when you do pass away without a will, the court looks at your property and they categorize your property as community property and separate property. Right now, we're going to discuss community property. And what community property is, or your community estate, is any property that you acquire while you're married. So that can be any land or houses that you purchase during the marriage, no matter whose name is on it. Any vehicles, earned income that's acquired during the marriage, that's considered community property. So what that means is that each spouse has a % interest in that community property. Okay, so when you pass away, the court or the law is concerned with dividing that property up. So you can only pass your interest in that property. So most of the time it's the 50% interest. So let's get into it. If you pass away with a spouse, but you don't have any children, then 100% of the community estate goes to that surviving spouse. So that surviving spouse keeps their 50%, and then they get your 50% when you pass away if you don't have any children. Okay. Now, if you don't have a spouse, but it's community property, maybe property that you acquired during the marriage when your spouse was living and your spouse passed away before you, but you have children, then 100% of that community estate goes to the children. The children will split it equally. Now, this third situation is what I see a lot of the times, and this situation causes a lot of issues, at least in my practice. It's if you're married and you have children. So I want to first start with if you're married and you only have children from that marriage, meaning, for instance, you married John, and you and John had 2 children together during the marriage. If that is the case, and there's no other outside children, just the 2 children during the marriage, that community property will all go to the spouse because the children are of the marriage. Now, if you have children outside of the marriage, meaning you may have had children from a previous marriage or from a previous relationship, and you also have children during the marriage, in this situation, only half of the estate will go to the spouse, which is that spouse's already 50% community interest, and the other half will go to the children, all of the children from previous relationships and during the marriage. All of the children would share the other 50% equally. So this may become the issue, and I've seen it a lot. People will come into my office and John passed away, and John had, 3 children from a previous marriage. And, his wife is telling me that those children were estranged. They never did anything for John. They didn't visit him. John didn't want them to have anything from the estate. And I have to unfortunately tell them he didn't have a will. And since he had outside children, all the children get a portion, regardless of what the situation was with them while he was living. And that a lot of times can cause issues. So it's important that, going back to what Attorney Cooper said, we get those wills done and drafted so we can make sure, the people that we want to have our estate gets our estate. Also, dealing with if there's a situation where there's no children, a parent has passed away, or there's no parents and it now has to be left to the siblings. I've seen issues with that because that can be a tricky situation too. And I've actually had a few cases like that. Siblings, sometimes it's hard to actually recognize who all the siblings are. We live, unfortunately, in a day and age where we have a lot of play sisters and play brothers and things of that nature. And a lot of times you'll have people claiming to be siblings and they're not actually, siblings. And then also you have the issue of half siblings. So half siblings don't get the same share that a full sibling would get. So it kind of becomes tricky and complex when you have to deal with siblings as well. Next slide, Attorney Cooper. Okay, let's talk about separate property or your separate estate. So your separate estate or separate property is any property that you acquired prior to your marriage or that you inherited from someone's estate. So that's considered separate property and it is not community property. So the court handles your separate estate in a different way. So they break it down into personal separate property and then real separate property. So personal separate property or your personal estate consists of like vehicles, clothing, jewelry, just personal items that are not land or real estate. And how that breaks down, your personal estate, 1/3 of it is given to your surviving spouse, and then 2/3 to your children or descendants. So your spouse only gets 1/3 of that separate property, and your children or descendants gets the other 2/3. And when we say descendants, that could be like grandchildren or any other descendants in your lineage. In regards to real estate or land, that's separate, meaning that was acquired previously to the marriage or inherited, that separate land, your spouse only gets a 1/3 life estate in that land. And what a life estate is means that that person does not have full ownership of it. They only just get to enjoy that land during their life. So they only get to possess it or enjoy it while they're living. Once that spouse passes away, then that land passes to the children or descendants. And so they share that 100% equally. So the surviving spouse only gets a life estate. So for instance, let's just say you have a married couple and the husband has a house that he purchased prior to the marriage, and him and his wife are living in that home. And the husband passes away while he's married to the wife. So that house that he had prior to the marriage, the wife gets to continue to live in it for the duration of her life. She'll be responsible for paying the bills on it, the taxes, the insurance, if there's a mortgage, any upkeep for the home. So she gets to stay in it while she's living. But when she passes away, then that house passes to his children or descendants, and they get to share that equally. So with separate land, only the surviving spouse only gets a life estate. So that's kind of a good thing, so that it provides that the spouse does have a place to live. If it was a separate property home, they're just not automatically kicked out at the death of the spouse. Now, if you do not have any children, but you do have your surviving spouse, then that surviving spouse gets your entire personal estate. So they get all of your personal property, all of your personal separate property. They get it all. And they get a half of your real estate, which is your land. This is if you don't have any children. Now, in regards to the other half of the land, that goes to the parents or the siblings as described above in the whole flow chart of how it passes out. So just remember, if there's no children and you have separate property, your surviving spouse gets your entire personal estate and 1/2 of the land. The other half of the land goes to the parents or the siblings. Next slide, Attorney Cooper. Now, whether you have a will or you die intestate, if you have assets, they're going to have to go through the probate process so that they can be distributed to your beneficiaries if you have a will, or to your heirs if you do not have a will. And that process is called probate. So let's start with if you do have a will. If you do have a will, as Attorney Cooper said earlier, in that will, you're going to name an executor. That's going to be the person who carries out your wishes and gives the beneficiaries what you've designated in the will. Now, in most wills, the executor is designated to be an independent executor, meaning they don't have to get approval from the court to act. I haven't seen any scenarios, at least in my practice, where I've drafted any wills where there was a dependent executor. Most of all of my wills, my clients have wanted their executor to be independent, meaning they function without having to get approval from the court. Now, if you pass away without a will and intestate, then that person is called an administrator. And that's the person who's going to make sure your heirs get their share of the estate. Now, that administrator can be independent or dependent. Typically, if all of the heirs are in agreement to have that administrator serve independently, then the court will name them as an independent administrator. And they don't have to get approval from the court to act whenever they need to do something. Now, in situations where all the heirs are not in agreement to allow that administrator to serve independently, then the court will name them as a dependent administrator. And what dependent administration means is that that person has to get approval from the court before they do anything with the estate. So before they do any distributions, before they sell anything or before they pay anything out of the estate, they have to get permission from the court. And that can be cumbersome with dependent administrations, because most of the time the court will make that administrator post a bond to ensure that if they misappropriate any assets of the estate, then they are bonded to protect the interest of the other heirs. So with dependent administration, it can make the probate a little longer and more expensive. So that's a kind of a downfall of, passing away without a will. You just don't know if it's going to be an independent administration or dependent administration, because you can have situations where the heirs may not trust you and want it to be a dependent administration. Okay, so with that, whether you have a will or not, you'll have to file an application with the probate court to get it started. Ask the probate court to either admit the will into probate and appoint you as the executor, or to determine to appoint you as the administrator and to determine who the heirs are. So that's the first step. You have to file an application with the probate court. Now with the will, once that application is filed, the probate court waits about 14 days to see if anyone is going to contest the will. So if no one contests the will, then they'll go ahead and set it for a prove-up hearing to appoint you as the executor and issue you letters testamentary. And those letters testamentary is a piece of paper with the official stamp from the county stating that you are the executor, and you can give that letters testamentary to anyone you need to, like a bank or bills, if you need to pay any bills for the people, anyone that is requesting to see documentation that you have the authority to act on behalf of the estate. So that's if you have a will. Now, if you don't have a will and we're doing the intestate process, we're doing the application to appoint you as the administrator and to determine the heirs, then it's a little bit more time consuming and can be a little bit more expensive, because the court has to appoint a separate attorney ad litem to investigate, well, to represent the heirs and to do like an investigation to make sure all of the heirs have been included and listed in the probate process. So depending on how many heirs that is, and if they're easily accessible, if they can be located, just depending on that kind of determines how long it's going to take. You have situations where, you may know that this person is an heir. He had, 6 children, but you don't know where all the children are located. And you kind of need to locate these children because they have to be put on notice that this process is happening. So that can hold up the process with the intestate succession process. Also, with the intestate succession process, like I stated earlier, all the heirs have to be notified, and in order to have it to be independent, they all have to agree to allow you to serve as the administrator and for it to be independent. And if they don't, then that takes more time because you're going to have a dependent administrator. Also within the probate process, whether it's a will or it's not a will, you have to publish a notice to your creditors that the person has passed away. And that's usually done in the newspaper, the most popular newspaper in that county, like for Dallas Morning News. You will post a notice in the newspaper, putting the public and the creditors on notice that this person has passed away. Also, like I stated earlier, the court will either issue the letters testamentary or letters of administration so that you can handle the affairs of the estate. Once that is done, you also have to do an inventory. And what that inventory is it's a list of all the assets and debts that that person had when they passed away. So the court requires that you provide that list or inventory to the court so that it can be known what all the assets were and what all the debts are. Now, after that, then At that point, you are free, if you are an independent executor or independent administrator, to distribute the assets of the estate to the heirs or to the beneficiaries. Now, if it's dependent administration, before you can do that, you have to get permission from the court to be able to make those distributions. So to summarize it, it's best to have a will, because if you do, when it's time to probate it, the process is pretty simple if it's a valid will that meets the statutory requirements for Texas. But if you don't have a will, it can kind of be time consuming and expensive, because you have to first make sure all the heirs are accounted for and that everybody's listed, and that hopefully everybody is in agreement to allow you to serve as the independent administrator for that estate. And I believe that is all that we have for you today. I think now would be a good time for us to take questions. I've seen a lot of them pop up on the screen. I couldn't read them all, but I think this would be a good time, Attorney Cooper, to take questions. What do you think?
We're open for questions.
Okay, so the first question, I think you answered it. Is there a difference if you are listed as an independent or dependent executor on a will?
Yes, it is. Independent basically means you can act without a court approval, and dependent means everything that you do, you have to get court.
And then the next question to follow that is, where might you suggest keeping the will if not in a safety deposit box? I've had someone was telling me that they lost documents because their home burnt down and the documents were in the home. So where do you have your clients, or what do you suggest to your clients?
I suggest, and what I did with my will too, is I deposit mine with the county clerk. So you can deposit your original will with the county clerk in the county where you live. Most counties charge anywhere between $5 to $10 to do so. And it's just to keep it safe. So when the time does come that you pass away, they already have their original. That's what I suggest for my Attorney Cooper.
I think that's a good suggestion. Or if you just have, a safe place at home, if you have a fireproof box at home as well, a fireproof kind of box, but as long as it's something that can be accessed, not a safe deposit box in a bank where it's going to be locked, where you can't have access to it.
That's excellent feedback. We have another question from Jennifer Neal that states, in a blended family situation, if one spouse dies, can a transfer on death deed be drafted by the living widow or widower?
No, the transfer on death deed can only be drafted by only the person who, you can only transfer what you own. In other words, the spouse can only transfer their portion of what they own. So one spouse can only transfer what they own, and the other spouse can only transfer what they own. So the spouse, if for two spouses, one spouse can only transfer their portion of ownership in that house, and the other spouse can only transfer their portion. So for two spouses who jointly own a community interest in a house, both of them would have to execute a transfer on death deed to transfer the 100% ownership in that particular property. I hope that answers that question.
Sure. And then speaking on documents, so in Texas, to be legal, do these documents have to have a certain amount of witnesses, or can you speak on the process of, do they need to be notarized? Like, what steps do we need now that we're familiar with what documents we need?
Yes, the deeds do have to be notarized by a notary, and then they do have to be filed with the county clerk. So yes, the deeds do have to be notarized by a notary. So they don't have to be witnessed, but they do have to be notarized by a notary.
Okay. And in regards to the will, I think I wanted to know about the will too.
Mhm.
The will does have to be witnessed by at least two disinterested witnesses. So they have to witness that, and it does have to be notarized as well. And they have to be subscribing witnesses. So they will sign what's called a self-proving affidavit. And so as long as the will is witnessed by two disinterested witnesses who sign a self-proving affidavit, then those witnesses do not have to appear in court later. So the will itself, it proves itself later by the fact that it has been witnessed properly, and this affidavit, which is attached, proves the will on its face. It's called a self-proving affidavit.
And then I want to add to that, I highly encourage people to have their wills drafted by a licensed attorney. I've had lots of situations where people come into my office with wills that do not meet the requirements for Texas law. And so we have to go through extra steps to get them admitted to probate. So some of those extra steps may include having to have one of the witnesses come to court, testify, or maybe the notary or someone who is familiar with the handwriting of that person. So I just highly encourage everyone to have it done by a licensed attorney. You don't have to, but a lot of those wills that you pull online or in books contain legalese that you may not know exactly what it means. And you think you're doing one thing, and in actuality, you're doing something else. I would encourage you to have it drafted by a licensed attorney.
So on that note, is there a specific number that you might have community members anticipate if they want to have to see a licensed attorney about like end of life matters? Or is everyone's consultation fees different, or what does that look like?
Okay, I guess I'm trying to understand the question.
Well, like how much does a good estate plan cost? I guess is the way to word it.
Well, of course, every attorney charges something different. For me, for example, I try to make it affordable because I do want as many people as possible to get wills. So I do charge a consultation fee, and my normal consultation fee is $100. And typically, if it's a pretty simple will, it's not a lot involved, you're not trying to do trust and all these types of things, I do charge a flat fee. And my flat fee is for a package. So it includes the will, your durable power of attorney, and your medical power of attorney. And that fee, flat fee is $500. And so 3 times a year, I do a special that's at Christmas, Mother's Day, and Father's Day, where I do it for half off for $250. So my normal package fee for just the basic will, medical power of attorney, and durable power of attorney is $500. But I do the special 3 times a year where it's half off.
Okay, thank you. That was what I was looking for.
Okay.
And then, so the next question is about what happens if one heir files to be an administrator, but you don't want them to be the administrator, and talk a little bit about when a will is contested.
Yeah, that is, those are exactly the situations that we face a lot. And so what can happen is a person can file a contest to contest someone being appointed as administrator, or they can file their own application if they want to also be appointed as the administrator of an estate. So I'm in the middle of a case like that right now. Those are they are gut-wrenching cases, and they can go on for months and years. They can really, really, go on. So what happens is you just have a full-out lawsuit where you have a trial before the court, where each person has to put on a case as to why one person may or may not be suited. Now, and there are certain rules in the law or certain, I guess, legal concepts that there's a presumption that if there's a surviving spouse, there's a presumption that the spouse is, presumed to be the better person to administer the estate. But if someone who is contesting it, say a stepchild, has reason to believe that they are better suited, or that the spouse, that there's some reason that they are not the best suited, then they can, come in and state their case. And in the case that I'm dealing with right now, as we speak, it was even a common law situation where there was a common law marriage, and the stepchild was contesting whether it was even a real marriage, and I had to even prove that it was a common law marriage to start with, and it's just the most, and so yeah, it's gone on for maybe over a year now that we have been contesting this case. So, and it was without a will on top of all of that. So, had there at least been a will, at least, married or not, it wouldn't matter, because if married or not, she could have at least said, whether this is my husband or not, I leave him this, and this is what I want him to have. It was because they had been together for 20-something years. And the daughter did not consider this man to be her mother's husband, and contested the whole thing. So yeah, it can get to be very, very, very messy.
And then to add to that, and I don't think I mentioned this, but the executor or the administrator, they need to be people that do not have any type of felony records that will disqualify you from serving as the executor or the administrator. And I've had several situations like that, where a person names, Johnny to be the executor, but Johnny has 10 felonies. Johnny can't serve as the executor. So we have to go to the next person. Hopefully they have listed as an alternate to serve as the executor.
And they have to be competent as well. There are some competency requirements as well in terms of their, mental competency and things of that nature.
Mm-hmm. And Attorney Cooper, there are a lot of questions about debt and debt being taken out of any assets and what happens with your credit card debt. And I know you spoke earlier about assets and liability. Would you care to answer those questions for us?
Okay, so just in general terms, what has to happen is once the estate has the notice of death has been filed, whether it's a will that's being filed or whatever is being filed, then the person who is appointed as the administrator or as the executor has a notice has to be filed by the court. Actually, the court will file notice to creditors, and basically like a hear ye. If you have any sort of claim against this estate, if this decedent or deceased person owes you any money, each creditor has a certain amount of time to file a claim with the court and say, this person owes me money. And so therefore, whoever is appointed to administer this estate, whether they are the administrator or the executor, whichever name it is, then they would then have to settle up with those creditors before they can then make any distributions to any heirs. So those debts have to be satisfied first. Typically, the creditors tend to accept pennies on the dollar. They just want to get something, but certainly those debts have to be satisfied before you can start giving out money to the heirs. So yes, those debts do have to be satisfied, but there's a process for all creditors to be notified, for them to file their claims with the court, and then for the court to make sure that those debts have been satisfied before monies can be distributed to the heirs.
That's excellent feedback. And so to follow up on that, how early or what's the youngest that you normally have clients that come in and want to talk about wills and estates? Or what should that process look like generation wise? Like if you're in your 20s versus you're in your 30s, or maybe you're retired. Could you go into that for us?
I'm thinking if you are ever at the point where you are actually acquiring assets. And so, I've got a daughter who is, looking at buying a house. I think if you, at some point where you're acquiring assets, if you're at that point in life, if you're at the point in life where you're getting married, then you've got to start making decisions of, if I pass on, what do I want to happen with my assets? If you're acquiring assets and debt, then you've got to start making decisions about what you want to happen in the event of your death. We're seeing people who are, passing on, and what happens after that. It may, a simple will is probably all you need at that age, but as you get older and things begin, your portfolio and and your situation may become more complex as you're having children, then you may need to look at some other things as to what do you want to happen with your children and things of that nature. But if you're old enough to have assets and you're old enough to have debt, you're old enough to have at least a simple will. Don't you agree, Attorney Pratt?
Yes, and then to piggyback on that too, I think you also need to make sure you have those power of attorneys, because just for me personally, my brother was 29 last year and he was in a coma for 3 months. So at the onset of the pandemic, I'm glad that I made him sit down and do those power of attorneys, because if I had not, I wouldn't have been able to take care of his business affairs, paying his bills and things of that nature, talking with different creditors and things of that nature to make sure that his business kept rolling while he was in the coma. So I say as soon as possible, at least get those power of attorneys done, because you just never know what'll happen. You can be in a car accident, get hit by a bus, anything.
No, that's very valid. And I spoke on that earlier about COVID, catching a lot of people off guard with things and being unprepared. With that being said, how often should we be updating or reviewing our documents? I think Attorney Cooper touched briefly on that earlier.
I agreed with Attorney Cooper. I do the same thing. I try to draft my wills to, account for all the contingencies and things that may happen in your life. But for sure, if you've had a major life change, like if you've had a kid, you've gotten married, gotten divorced, you've acquired a new business or a new asset, definitely you want to look at that will to make sure that it's accounting for that.
Okay. And speaking of assets, Deborah Franklin asked, is there a recommended estate value before considering a living trust?
I'm not a fan of trust.
Yeah, me either. They're really cumbersome, and I don't know that I would say an estate value. I would say maybe if you have a certain, maybe just a number of different assets and a variety of different assets, whether it is business holdings and personal holdings and that type of thing. But again, before considering that, I would really, really recommend speaking with a tax attorney, because there are so many tax ramifications to that. And if all you're really trying to do is to shield your real estate from the probate process, that can most easily be done with a transfer on death deed. Mm-hmm. And if you're trying to shield any sort of cash accounts, you can do that many times with the payable on death type account. There's just so many different ways to avoid probate without doing that. So that's my answer. I don't really have an answer in terms of a cash value of your estate and when that becomes a benefit, when that becomes a benefit for that. So
okay, I appreciate.
Hi, Deb. I know Deborah.
Oh, okay.
We went to high school together.
So I just want to thank you both. And unfortunately, we've reached the end of our time for questions and answers. For those who are attending, if you look in the chat, we have shared both of the attorneys' information for additional questions, as well as a survey link. I would like to introduce our second Vice President, Cherry Elder.
Thank you so much. As stated, my name is Cherry Elder, and I am the second Vice President of A Vision Fair, an official interest group of Alpha Kappa Alpha Sorority Incorporated. We want to thank our speakers, Attorney Andrea Cooper and Tiffany Pratt for joining us and providing your expertise on how especially important and serious preparing for the future truly is for our families, as well as to maintain the worth and placement of our values, which range from our businesses and to our properties, houses, land, and cars, as well as our children. Most importantly, thank you for joining us, for listening, for asking questions, and for being a part of this workshop. We hope that you've gained some information that you will pass along to family, friends, and will assist you and equip you in planning for wills and estates. As stated previously by our mistress of ceremony, a survey link has been placed in the chat. We would greatly appreciate your feedback regarding our workshop today. Again, thank you and have a wonderful day.